Copyright, trademarks, patents, intellectual property. What's the difference? I'm Andrei Mincov, the founder of Trademark Factory. And in this video, I'm going to explain to you how this works in plain English so that even a 9-year-old would understand.
Get it trademarked with Trademark Factory.
Now, I explain these concepts in my best-selling book, The Ultimate Insider's Guide to Intellectual Property. But I wanted to shoot this short video and explain it even simpler, give you a summary of a summary, and leave you with enough information, enough knowledge, so that you could use that to quickly tell what you can protect with what and what you should protect with what. So let's get started. First of all, intellectual property as a term is an umbrella term. It comprises of completely different areas of law that vary in some very important aspects. So when you say I own intellectual property, it's really meaningless unless you really understand what you own, right? You can own copyright in some things, you can own patents in certain other things, you can own trademarks in certain yet other things. But when you just put everything under, well, I own all IP, usually it means you probably don't own anything because you don't know what you're talking about. So let's go through the different areas of intellectual property. I'll explain what they cover, what things are important about them, and when to use those laws to protect certain aspects of your business, of your creativity. Okay, so intellectual property as a whole, like I said, is an umbrella term, and it protects different aspects of human creativity, right? All types of intellectual property, in a nutshell, protect intangible results of human creativity. It's just that those results are different. So before I introduce the different types of intellectual property, I just want to make a very short introduction that I like to use what's called magic words for each of these types of intellectual property. So basically, one word that you should remember about each of these types of law so that you know exactly what protects what. Okay, so let's start with copyright. Okay, copyright, the magic word for that is how. Generally, copyright protects content. It protects books. It protects videos. It protects movies. It protects photographs. It protects software. It protects songs. It protects multimedia. So anything about content. And when I say content, copyright doesn't protect the underlying ideas of your content. It doesn't protect the knowledge that you express in your content. It doesn't protect the skills that are required to create that content. It protects the content itself in the sense of how were you able to express that content. So, for example, again, my book, right? I wrote the book on intellectual property. Just because I wrote a book on intellectual property, it doesn't mean that nobody else can write another book on intellectual property. So this book is protected by copyright as content, which means that nobody can take a chapter out of this book and just reprint it without my permission, which means that nobody can take a chapter out of this book and claim it that they wrote it. Nobody can just rewrite the whole thing, maybe change a couple of words and say it's theirs, right? But the concepts that I share in the book they're not protected by copyright. Ideas are not protected by copyright. Methods are not protected by copyright, right? So that's why I use the magic word how, because how is all about how did I express those thoughts? How did I choose to write the book? Which words did I use? Which order of words did I use? Which order of the chapters did I use? Those things can and are protected by copyright. Now, an interesting thing about copyright is that it arises automatically. You don't need to register copyright to have your content protected by copyright. The second you finished writing your book, the second you finished writing your even a chapter of that book, as soon as you finished writing a sentence that will become part of your book, you own copyright in that sentence. As soon as you finished writing the song, you don't have to have it recorded by a professional singer. As soon as you wrote it down, either as notes on note paper or maybe played a really rough recording of it or whatever, right? Maybe you even whistled it to your iPhone. You own copyright in that. That's both great because it's so easy to protect, but it's also extremely dangerous because other people have copyright in their content exactly the same way. So don't assume that just because you can find it through Google, you can simply use it. That's not how it works. Most of the things you can find is probably protected by copyright, and in most cases, you gotta ask permission. And if you don't, you may run into significant troubles, right? So same idea with, let's say, Google Images, right? You can find any image out there, but unless you really look into it, you may run into images that are protected by copyright and you can't just take them and use them, which is why I always recommend that for any business purposes, if you're putting something out there, much better to use those stock websites, like Deposit Photos, or there's so many of them. Just get that image, pay $1 or whatever they're going to charge you for it, and know that you have a license to use it and nobody's going to go after you. Okay? So that's copyright. The other thing about copyright that you should know is that copyright lives for the entire life of the author who created the content all the way to their death, plus, depending on the country, 50 or 70 years after they die. So the whole idea behind that is to give protection to 2 or 3 generations, right? And because otherwise it'd be so easy to just shoot the author and say, well, now this work is in the public domain. We can do whatever we want with it. So that's not how it works, of course. So again, very easy to protect. Don't need to do anything. You can, in certain cases, register your copyright, which may give you some additional procedural advantages, but your ownership does not depend on you registering it, okay? And once you've written it, you have your whole life of protection plus 50 or 70 years after you die. It's a long time, okay? Now let's go to trademarks. And as a founder of Trademark Factory, you may think that this is my favorite, and maybe it is. So trademarks are a totally different beast. They're not about content. Trademarks are about identity, which is why I always give them the magic word, which. Imagine you're walking through a store and there's a shelf, and on that shelf, there is all sorts of different products, different brands, but maybe there's ketchup, okay? So how different can a ketchup be, right? So there's one bottle, there's the other bottle, and they both have ketchup in them, or shampoo, or whatever, right? So a trademark is that which allows me as a consumer to tell your ketchup apart from somebody else's ketchup, or your shampoo from somebody else's shampoo, right? So it's not about functionality. It's not about which ketchup is yummier. It's not about whose shampoo washes your hair better. It's not about the results. It's not about the features. It's not about the benefits. It's about identity. How do I know that if I'm shopping for Nike sneakers, I'm buying Nike sneakers and not some other sneakers, right? That's the purpose of trademarks. Trademarks protect brands, whether it's the name of a product, a name of a service, a name of the company, a name of a feature sometimes, or a slogan, or a tagline, or a logo. That's what trademarks protect, but they protect it as identity of a particular product or service, okay? So that's what trademarks are all about. And in theory, trademarks is the only type of intellectual property that can last forever. As long as you can renew them and renew them and renew them on time, you can own your trademark forever. That's how Coca-Cola has been renewing their trademarks since 1892, right? It's one of the best examples of a long-lasting trademark. And all they did, they filed their trademarks when they were just starting out. Actually, they filed their first trademark when they were selling 9 drinks a day. And they have been renewing their trademarks every 10 years ever since. So that's trademarks. And in most countries in the world, the only way to protect your brand through trademark is to register that trademark. Okay, there are a few countries out there, US, Canada, UK, a few others, where there is some limited, very limited protection to unregistered trademarks. They call them common law trademarks. But even in these countries, it's still much better and well recommended to register your trademark, because unregistered trademarks are very difficult to enforce, and sometimes you can't enforce them at all. And like I said, in most other countries, unregistered trademarks, it's not even a thing. It's either a registered trademark or it's not a trademark. So if you're serious about your business, make sure you register your trademarks. Okay? Now that's trademarks. So again, just a quick recap: copyright, how protects content; trademarks, which protects the brand. Now the next one I'm going to talk about is patents. Patents, the magic word is what? It's as close as you're going to get to actually protecting the substance of what you came up with, right? It's the invention that you can protect with a patent. And there's really 2 types of patents. You can protect the product. So if you came up with some innovative product that hadn't existed before, you've thought of some really cool feature for a product and nobody's ever done this before, that product you can get a patent on. And if you do get that patent, that nobody else can make or sell products with that feature that you claimed as part of your patent. The second type of patent is a method patent, which says you invented a certain way of doing certain things that you don't want others to replicate without a license. So it's not about the particular product. It's not necessarily about the result. It's about the way to get there. And in different situations, you may want to go with either a product patent or a method patent. Well, sometimes you need to get both, right? And sometimes getting both gives you the most protection. Now, with patents, there are a few problems because they give you such a strong monopoly. Basically, you could be the only person in the country or in those countries where you get that patent, because patents, like all intellectual property, are done on a per country basis. You could be the only person who is allowed to make a certain product, and you can stop anybody else from making the same product with the same features. So because this is such a strong monopoly, what they've done is they made that monopoly very, very short, right? In most countries, it's about 20 years. And on top of that, it's 20 years from the date of filing of your patent. And in many countries, it takes about 5-6 years to even get that patent registered. It's a very slow process. So if you thought that trademarks take way too long, which is about 18 months, now more than that in Canada, about 14 months in the US. If you thought that that was long, well, think about patents, right? They take 5-6 years. And they're massively more expensive than trademarks. Patents are a lot more expensive. Plus, there's annual maintenance fees. And if you do patents in many countries, you could easily be looking at multiple 6 figures, multiple hundreds of thousands of dollars to get that patent registered and maintain it over the life of the patent. And after the patent expires, well, guess what? In order for you to get the patent, the deal is that in exchange for granting you the patent, for granting you the monopoly, you have to disclose to everyone all your secrets about your invention, so that by the time your patent expires, anybody could look at your patent and replicate exactly what was so valuable about your patent. So that's a huge trade-off. So it takes forever to get it. Then you only get like 14 years to enjoy that monopoly. And then anybody can make that and replicate that without asking you, without giving you any credit, without paying you any licensing fees. Okay, so that's what patents. And so so let me kind of give you the breakdown almost as a summary. So talking about patents that expire, think of generics, generic drugs, right? All the pharmaceutical companies, they always get patents on their medicine because it takes a lot of money, a lot of research to come up with something new. And so they get a patent on that. And then several years later, all those generics start to pop up, right? Why? Because the patent is already expired and they can see the formula because the formula is disclosed in the patent, right? And guess what's left? So let me give you an example. Viagra, right? One of the most famous examples, right? It generated many millions and millions and millions of dollars for the company that invented it, Pfizer, right? Well, Pfizer as a company didn't invent it, the inventor invented it, but Pfizer bought the patent. They owned the patent. And for many years, they were able to enjoy the monopoly. They were able to stop anybody else from selling the pill that had that formula because that was their patent. Now, at a certain time, the cutoff happened and the patent was no longer valid. And so anybody else, it's perfectly legal for them to go out there and make the same pill and say, that's the pill. Well, guess what they cannot do? They cannot call their pills Viagra because that is a trademark, right? So that's the difference. You can make the pill, you can't use the brand, and you can't use even references to their brand. You can't make comparisons to their brand because that's the trademark that Pfizer still owns. And so do you see how valuable that brand is? Because many people would still prefer the original brand over a generic, which is exactly the same pill, just under a different brand. So again, recap: copyright, content, what? Trademarks, which? Patents, what? Okay, now, because patents are so expensive and because they're so short-lived, there's another variation of how you can protect the substance in certain cases. And that's trade secrets. For trade secrets, I use the magic word hush, because with trade secrets, you only get protection insofar as you can keep your idea confidential, right? The second it stops being a secret, you have no protection. And that's really what separates the advice of, yeah, you gotta go get a patent from, well, maybe you should just be quiet about it and not tell people how this works, and then you'd be able to protect it with a trade secret. And so trade secrets will last for as long as the information remains confidential. And so if somebody can figure it out on their own, how this works, why it works, what the formula is, you got no trade secret on that anymore. If it becomes so obvious that anyone understands it, you're done. If you're not taking proper steps to protect confidentiality of your trade secret, you're done. If you go about telling people on your video blogs, how something works, you're done. It's not a trade secret anymore. But if you invented something that's not really clear how it works, what's it made of, and you don't want people to find out, which they would if you filed a patent, then you may want to try to protect it through a trade secret. And really the only protection there is that you don't tell people what it is unless they sign what's called a non-disclosure agreement, an NDA, right? So you can disclose your secret to others as long as there's a very clear understanding that they won't do anything with it, they won't disclose it any further, and that they will continue to preserve confidentiality of your trade secrets. So that's trade secrets. Like I said, can't last forever, cost almost next to nothing to protect, because all you need to do is just not tell people about it. And they can be more powerful sometimes than patents, because patents are easier to overcome. With patents, change a little bit and feature here, feature there, and sometimes your amended product doesn't infringe the patent anymore. With trade secrets, not so much, because it's so intangible, right? There's no formula that sometimes it's more powerful. So think of Coca-Cola. Originally, back then, first thing they did is they actually tried to get a patent on their formula. And they got the patent, and that's when they realized about 20 years later, or about 15 years later, that, whoops, our patent is about to expire, and now the formula is known to everyone. And so there's nothing proprietary about the recipe anymore. And they thought, we might probably stay in this business longer than 20 years. And so they came up with the improved formula, and this time around, they didn't go for a patent. They said, we got a new improved formula. This is pure magic. Compared to what we used to have, this is 1,000 times better. But you know what? We're not going to go for the patent. We're not going to tell you what it's made of. We're not going to tell you the recipe. We're just going to put that recipe in the vault, create a really sexy story about it, in terms of making sure that, nobody knows the entire recipe. Some people know parts of it. And this is how they created the legend around the Coca-Cola recipe. It's still protected as a trade secret because the information is still confidential, and still people don't know exactly what the ingredients are, how they're mixed, and how it's done. So that's your trade secrets hush. Okay? Now, the other type of intellectual property is design patents, or industrial designs, as they're called in Canada. The magic word for them is wow. And what they protect is design aspects of physical products you sell on the marketplace. It could be ornaments, it could be shapes of products, basically something that has value because of its looks, right? Maybe packaging, maybe some unique shape of a product. So a few things to know about this. It only covers physical products that have some unique appearance, something unique about them. And two, they're extremely short-lived, even shorter than regular patents, really 10 years. And very, very difficult to get them because you have to have something unique, you have to have novelty, worldwide novelty, by the way. Same as regular patents, right? You can't go to one country and say, oh, that's a great product. Why don't I bring it to my country and get a patent on that? That's not how patents work. Same with design patents. You can't have seen a great ornament or a great product or a great shape. Like, oh, that's a great idea. I'm gonna go ahead and try to get a design patent on that in my country. You might get away with making or selling products that are only patented in one country but aren't patented in yours, but you wouldn't be able to get your own patent because patents require worldwide novelty. Okay, so that's the 5 types of intellectual property in a nutshell. So copyright, how, protects content; trademarks, which protect brands; patents, what, protect the substance of your invention; hush, for trade secrets, protect your confidential information; and then wow, design patents or industrial designs that protect the looks of your physical products to the extent that there's something unique about them. And there's another one that I always end with, which is intellectual property contracts. And contracts, believe it or not, can be stronger and more valuable than any of these other 5 types of intellectual property. Why? Because contracts can create rights that hadn't existed before, and they can destroy rights that did exist before. So you can, in a contract, create rights just by saying, I agree that I will not copy your product. So you may go to a factory and say, look, let's agree that if we give you this order, you will not make this product for anybody else. You're just gonna do it for us, right? You may not have a patent. You may not be able to protect this with a trade secret, but having that contract allows you to go after the factory if they did, in fact, start making the same product for somebody else. So that's what contracts can do. And also, similarly, contracts can destroy rights. So you may be the original author of a book or original author of a song, but if you sign a contract whereby you transfer that copyright over to somebody else, well, that's it. You no longer own it. They do. So be very, very, very careful what documents you sign, what contracts you sign, and make sure that if you're using somebody else's works, somebody else's IP, that you get them to sign whatever paperwork is needed for you to be able to safely enjoy all of that. Now, I hope that this little introduction to intellectual property was useful for you. Quick recap: copyright, how, protects content; trademarks, which, protect brands; patents, what, protect inventions; hush, for trade secrets, protect confidential information; wow, for industrial designs or design patents that protect the looks of physical products. And I didn't tell you that. So the magic word for contracts is whatever, right? Because you can create whatever you want through the contract. So with this, I believe that you're well equipped to look at any situation that your business may be facing and decide what you need to do to protect your assets, right? If you're writing content, if you're heavy on content, well, you know that it's protected automatically. You don't have to register anything. Sometimes it may be a good addition, but it wouldn't affect the ownership. And you know that you shouldn't use other people's content without their permission. You also know that if you came up with some revolutionary idea, a new product or a new method of doing something? Well, there's really two avenues. You can either try to get a patent and know that it will be a very long process that's going to cost you a lot of money. And even if you succeed, you're only going to have a few years to enforce that monopoly. Or you could go the trade secret route, don't get a patent, don't spend that money. I always say, if you can protect your invention other than through the patent, don't get the patent. Just go through the know-how. Just go through the trade secret, right? That's the posh part of it. And make sure that you protect your brand, because the brand can live forever. And the brand can live on and on and on when nothing else is proprietary about your business. You can still rely on your brand to tell people why they should go and buy from you versus somebody else. Now, if you found this video useful, if you found it helpful, subscribe now and get notified whenever the next video goes live. And by the way, we post videos like this every single day. Some are FAQ videos, some are my answers to specific questions people ask me on social media, on Quora, on YouTube. Some videos are me commenting on news of the day. We call them trademarking screw-ups, but there is always something happening in this channel. Make sure that you become a part of this. So subscribe now and get notified whenever the next video goes live. And until then, I'll see you in the next video. And by the way, this book, like I said, provides a lot more details. So if you want more details, get the book.